Hello everyone. So today's video is about the Gratuity Act of 1972. As in our previous videos that we have discussed, the Employee Provident Fund and what are its eligibility and applicability, as well as we also discuss about the Employee Pension Scheme and along with its eligibility as well as the applicability. So in this video, we're going to look about the Gratuity Act of 1972. Basically, what does this gratuity mean? It is a voluntary amount that is given to an employee of a company when he is leaving the company, like after his retirement. So the company is voluntarily giving a certain amount to his employee. Whereas from the point of a company, this gratuity is considered as a liability for them because they need to pay some certain amount. This act comes under the 1972, and now we're going to discuss what are its applicability as well as eligibility. So applicability is nothing but any company which has a manpower of 10 employee. So that company can apply for this gratuity act for those employee. So this becomes one of the most important as well as a beneficial for those employees of the company. And this eligibility for the employees, it is not that every employee will be get this gratuity benefit. It's not like that. It is for those employee who has um, the number of years of continuous service in the organization, not continuous service, which means of they work in the organization continuously without of any jumping from one organization to other. So that continuous service for that organization should be of 5 years, 5 years of continuous service. So for those employee, this gratuity will be get applicable and they were eligible for this. And for example, to be considered that if you take the employee X, he work in organization of XYZ from 2001 and 2004, but after 2005 he left the company and he joined for other organization, and he again come back to the same organization of XYZ in 2007. Then that employee is cannot be considered for this gratuity act because there is a gap of 2 years then. So that's the reason this eligibility is not applicable for those employee who don't have the continuous service. But this condition is get exceptional in one of the following aspect. So that aspect we're going to be discussed in this then next in the upcoming topics. So other thing is nothing but when basically and discontinue will be happen. It's happen based upon when an employee take some unpaid leave or medical leave or maternity leave for the female employee. For these three conditions, this eligibility has some exceptional rules. For this conditions, what happened? Even those employee who take any of these types of leave, they still eligible for the gratuity because they're not getting terminate from the company. They still be the member of the organization, but they coming under these three conditions. So the reason, if you take the example like uh, the employee X, he taking an unpaid leave in a year, but he has continuous work of 4 year, and coming on his fifth year, he has been taken some unpaid leave, and he is continuing on his to next year. So there is a gap of 1 year, but still this employee is considered to be eligible for this Gratuity Act of 1972. So next is that how to calculate this gratuity that we're going to look now. Basically, this calculation of the gratuity is get different from the two category. Basically, the company working days is get differ. Like some company, they have the working hours like 5 days from Monday to Friday. Some other company, they have working hours, working days from Monday to Saturday, so 6 days. So we can be consider the company which has working day from 5 days per week is category 1, and 6 days per a week is called as category 2, sorry, category B. So in the case, any employee is comes under the category A if you work for 190 days a year, will consider to be the 1 year. If you work for 95 days a year, then considered to be the 6 month, like 6 month for the year. Similarly, when the employee from the category of B, he works 240 days a year, and then that is considered to be the 1 year. Whereas if he's worked for 120 days a year, then he considered to be the 6 month. So there is a huge difference between this. Like the calculation of this gratuity is based upon the working days, and this really gets different with the company who works 5 days a week and who works 6 days a week. And coming to this gratuity formula, so here is the formula that. So we calculate this gratuity taking the last drawn basic salary and divided by 26 into 15 into number of years of continuous service. So here the number 26 is basically takes a month. In a month, basically there will be the 4 holidays maybe there in Sundays. Whereas in a month there is a 4 week in considering in leaving the Saturdays, remaining we have the 26 days. That's indicate the number of 26. And whereas here the 15 is considered to be the fixed factor. So this is the formula to be calculate the gratuity. And basically the gratuity, what is the maximum gratuity that the employee can expert can get is he can get the maximum gratuity has 20 lakhs when he is leaving the organization, where that 20 lakhs is considered to be the non-taxable gratuity. It is not that it is only 20 lakhs that the maximum amount that he get as a gratuity is. Even while doing this calculation of the gratuity for employee, that is coming like more than 20 lakhs, like we take here as a 35 lakhs, whereas the 35 lakhs is not be given to the gratuity to the employee. So the 20 lakhs, that is a maximum. Even he gets more than like 25 or 30 lakhs, but the giving amount should be like a 20 lakhs, that's it. So whereas while the calculation that has been showing the more than 20 lakhs, like 35 lakhs, and we have been giving only the 20 lakhs as a gratuity, the remaining 15 lakhs that is considered to be a taxable gratuity for the company. And this payment timeline, basically the employees what happened, they may be giving some the date of resignation and date of leaving. So any employee in the organization, he has been submitted the date of resignation, and from that date starting to 30 days within, you need to pay his gratuity if he is eligible. So that is a payment timeline. If you have been supposed to pay the gratuity to that candidate, whereas they may be the interest will be deducted for the company to pay interest in a per day, where the interest get adding each and every day for that. So that the case. And compulsory insurance, this compulsory insurance is very important for those company and also for the startups, because as I said in beginning of this video, that gratuity is considered to be one of the liability for the company. While to solve this thing, there is some term that called as a insurance, compulsory insurance. Any company with the manpower of 500 plus, Or even nowadays, even the startups with the manpower of 100 or 200 employees, they also, applying for this gratuity and applying for this compulsory insurance. So how this work is basically, you take a company of XYZ, and this XYZ has been paying some premium amount for any insurance company. Let's consider as a LIC. So while the time of the XYZ company's employee, while he's leaving the company, his gratuity amount is being given by that insurance company, so that the company can be free from the liability, but they will be paying the premium monthly in case the most of the company, at the end they maybe have some bankrupt or some shortage of money, so they can able to be resolve this issue from that. And other thing is nothing but recovery of gratuity. If an employee fail that to pay the gratuity within the prescribed time, within the 30 days of the termination of employment, the controlling authority is empowered to issue a certificate to the collector to receive the amount of gratuity. And the employee shall also be liable to pay the compound interest as a rate may be noticed by the CG from the time to time. As we discussed that, so this interest will becomes the compound interest each and every day, where the interest getting adding by the day by day. Interest shall be paid from the date of expiry of the prescribed period and ending actual date of payment of gratuity. And the interest payable shall be not exceed the amount of gratuity payable. And other thing is nothing but, can any disqualification can be there for any employee from the gratuity payment? Yes, it is there. It is there for the employee who damage the company's asset in a physical, in a monetary aspect. If they made any loss to the company, so at this time, the company can reject this employee from the gratuity. So the company has a right to reject this employee. If this employee is eligible for the gratuity, this company can able to reject from you. And other thing we need to discuss is nothing but the peace rated employee. Peace rated employees, those employee who works in a, you know for certain period of month. For them, calculation of this gratuity will be taken as from the last drawn wages into the 15 divided by 26 into the complete year of service. Whereas the pot of year in X of 6 months. And other employees, nothing but the seasonal employee. Seasonal employee, or those work will be only on the seasonal times in a year. Like they work for 3 months in a year or the 4 months in a year, that's it, because that's seasonal. Like best example to be shared to is that sugar mills. So for those employee, we consider to be pay the gratuity at the rate of 7 days wages for each session. So this is all about our topic of Gratuity Act of 1972. And if you people have any doubt regarding this topic, anything, you can just share it in a comment box and I'll be let you know. And I want all you people to share, like, comment and subscribe to my YouTube channel so that you'll be getting some constantly HR related topics and concepts. Thank you all.